Today we'll start with the court procedure, legal aspect part 2. That is court procedure. I am Professor Dr. Muhammad Shah, Professor Head of the Department of Forensic Medicine, Ibrahim Medical College. In the last class, we discussed about the court legal structure of Bangladesh. Today we'll discuss about the court procedure. At the end of we have to define and classify evidence and witness. Describe the procedure of recording evidence in court. Enlist the type of documentary evidence. Describe the procedure of taking dying declaration. Explain the conduct of a doctor in a witness box. Can anyone say which one is more important skill that every physician needed? Dr. Sharif?
जी सर सर विटनेस हेलो হ্যালো জি স্যার স্যার কোশ্চেনটা আবার একটু করেন শুনতে পাইনি স্যার হ্যালো
মানে
জি স্যার
which skill, which is one of the essential skill that every medical doctor has needed?
স্যার ক্লিনিক্যাল স্কিলটা দরকার সবার এবার মানে ও স্যার মানে যেটা বললেন যে মানে কোন ইয়াটা দরকার সকল মেডিকেল প্র্যাকটিশনার স্যার অবশ্যই রেজিস্ট্রেশনটা দরকার প্রথমে
By this, that is define and classify evidence and witness. Among the evidence, witness,
দুটোর মধ্যে স্যার
of recording evidence in the court, type of medical documentary evidence, procedure of taking dying declaration, conduct of a doctor in a witness box. Of these, which one is more essential for every practitioner, medical graduate?
স্যার উইটনেস স্যার
I think procedure of taking dying declaration is one of the important skill that the medical graduate may face in their clinical practice at any time, may be faced. Another skill that every doctor is needed, the conduct of a doctor in a witness box, how to give evidence in the court, and that is ideal witness, characteristic features of ideal witness. Let us discuss. We'll discuss about the court procedure. Among the court procedure, there is a summon, a document which demands the attendance of the witness in the court, the evidence, that is the statement or means which prove or disprove any question in legal affairs, and witness the person who state to explain statement in the to give evidence in the court of law. Among the court procedure, these three things we'll discuss on by on of them. Summon. Previously we discussed this portion also. Summon. Another note is synonym is subpoena. Is a written document, a read or document served to a witness compelling the attendance of that witness in the court of law at a particular time and date for the purpose of giving evidence under penalty. This penalty means if you fail to attend in time without a reasonable cause, you will be compelled to attend by issuing warrant. That's why it is known as under penalty. So it is not a simple document or simple paper served to witness. It is not a simple notice. Therefore, summon is a document. It has a tremendous legal value. If you fail to attend without reasonable cause, without reasonable cause, you will have to pay damage in case of civil, and you have to face fine or imprisonment in case of criminal cases. This is a summon. Let us see where you can ignore a summon or what you have to do if you, the condition where you can ignore a summon, or what are your duties if you get summoned to attend 2 or more different courts in the same date. If you get summoned from lower court and higher court, you can ignore the lower court. You can first attend the higher court with intimation to the lower court that such and such date I have to attend the higher court. That's why please fix me another time for me for giving evidence. If it is civil court or criminal court, you get someone from both these court to attend in the same date. You'll first attend the criminal court, ignore the civil court, but you have to give information to the civil court. Then such and such day, I will have to attend the criminal court like this. If the same status, then attend the first, receive the summon in that court. And if you seek, then you can ignore, but you have to inform to the court. These are the conditions where you can ignore a court instead of another court. And these are also your duties. If you get summoned from the lower court as well as higher court, you first attend the higher court with intimation to the lower court that I am attending the higher court. I will not be able to attend your court. Please fix another date for me. I will have to attend the higher court. So, like session judge and joint judge. Session judge and joint judge. District session judge, and if you get someone from the district session judge as well as from the joint session judge, you first attend the session judge, district session judge, with intimation to the joint session judge that I have a summon to attend in this time at the district session court. So I will not be able to attend your court. Please fix another date for me to give evidence. For same, if it is civil or criminal, you first attend the criminal court with intimation to the civil court. And if the same is, then you can attend the first receipt, the summon from court who is you first received. And if you seek, then you will inform this. These are the conditions where you can ignore a summon from a court, or these are the conditions where you have some duties to attend here. There is a term conduct money. Conduct money is the fee offered or paid to witness in a civil case at the time of serving the summon for attending the court, for the cost of attending the court of the witness. But this money is not now practiced. But every student of second Prof, they have to face this definition of conduct money. Often you are asked to define conduct money. Now come to the evidence. Evidence all means which prove or disprove any fact in legal question and include any statement or all documents, either document or a statement. Another way you can say all statements which the court permits are required to be made before it by the witness in relation to matters of fact under query. All statements which the court permits or require to be made before it by witness in relation to matters of fact under inquiry. Or you can say all documents produced for inspection of the court. So we define the evidence in these three ways. These are the all means, maybe a statement or documents which prove or disprove any fact in legal question, that is evidence. Exhibits. Dictionary meanings of exhibit: to submit something, either document, clothing, weapon, to a court in course of proceeding, or to present officially or in a legal form. These are the dictionary meaning of exhibits. Exhibits are the clothing or weapons, etc., sent for examination for the inspection of the court. And these, whenever produced to you, these exhibits, whenever produced to a forensic scientist, forensic medical legal expert, or medical legal consultant, these exhibits, whenever sent for examination, should be described in detail, sealed, and returned to the police. There is a term chain of custody. Chain of custody in legal context is the chronological documentation or paper trail that records the sequence of custody, control, transfer, analysis, and deposition of the physical or electronic evidence. Idea behind recording chain of custody is to establish that the alleged evidence is in fact related to the alleged crime. Chain of custody is the method to verify the actual possession of an object from the time it was first identified till offered as evidence in the court. Let us see the importance of chain of custody. Maintaining a chain of custody is essential for the forensic scientist working on a specific criminal case. The documentation of evidence is the key for maintaining a chain of custody. The documentation of the evidence is the key for maintaining a chain of custody, because everything that is done to a piece of evidence must be listed, and whoever came in contact with that piece of evidence is accountable for what happens to it. This prevents police officer and other law official from contaminating the evidence or taking the piece of evidence. Chain of custody is very much important. It is the body of the crime to prove the body of the crime in case of murder or in case of any criminal offense, to give punishment. Types of evidence. It may be direct evidence, circumstantial evidence, substantial evidence, corroborative evidence. Substantial evidence, the evidence that is a reasonable mind could accept as adequate to support a conclusion. This is substantial evidence. But corroborative evidence will support other evidence, either strengthening that evidence, adds to that evidence, authenticates that evidence, confirm that already existing evidence. Direct evidence, this is person who saw it or in contact with it. Direct and circumstantial evidence differ in their logical relationship to the fact in issue. Medical evidence is only corroborative evidence. It is not a substantive evidence. So it has a more important. For examination purpose, direct evidence may be oral or documented. Type of evidence for examination purpose, you can say like this: oral evidence and documentary evidence. Oral evidence may be direct, may be indirect, or hearsay, and documentary evidence. Medical documentary evidences are of three. One is medical certificate, another is medical legal reports, another dying declaration. Dying deposition is not a medical documentary evidence. And in the book, textbook, you will say this dying declaration, dying deposition is written in a small letter than that of dying declaration. But it is very much important to differentiate dying declaration and dying deposition. Medical certificate, birth certificate, death certificate, certificate of illness, certificate of fitness. Medical legal report, injury report, postmortem report, report on rape or sexual assault, report on estimation of age. These are the medical legal reports. What is the difference between medical certificate and medical legal reports? There is a question whether both are issued by the doctor or not. Can anyone say? Medical certificate, these are issued by virtue of your practice. And medical legal reports, we only serve whenever a requisition from the law enforcing agency or court is asked to make the examination. On that basis, we prepare it. Medical certificate will be granted as a documentary evidence in the court whenever it is issued by the registered medical practitioner. Medical legal reports are accepted in the court as a documentary evidence after giving oral testimony. Dying declaration will be accepted in the court as a documentary evidence whenever the dying person died. Dying deposition, this is also a bedside court. Document accepted without a oral testimony. These are the dying declaration. If the person died, printed of opinion of expert, experience treatise, author, date. In that case, deposition of medical witness taken in a lower court, deposition in a previous judicial proceeding, chemical examiner's report, DNA profiling report, fingerprint report, ballistic or explosive report, public records, birth, death certificate, birth, death registration, marriage registration, etc., hospital records. These are the documents that are accepted in the court without oral testimony. So it is clear to you, medical certificate that will be accepted in the court whenever it is issued by the registered medical practitioner. Medical legal reports will be accepted in the court whenever the person who prepared this give an oral testimony in the court. Dying declaration will be accepted in the court whenever the dying person died. The death of dying person, after death, dying declaration will be accepted in the court. Dying declaration is one of the important skill that every doctor should know it. It is the legal right of the patient, and if the doctor fails to record the dying declaration, he may have to face negligence case. Dying declaration is the written or oral statement of a dying person in presence of two witnesses relating to the fact of cause of his death that result of unnatural act. Though I fragmented this definition, but this definition is on a continuous process. That is, dying declaration, you may define dying declaration. This is a written or oral statement of a dying person in presence of two witnesses relating to the fact of cause of his death that resulting from an unnatural act. Dying deposition, a statement of a dying person. This is a statement or written or oral statement of a dying person. This is also a statement of a dying person. On oath, dying deposition, statement of a dying person on oath recorded by magistrate in presence of accused or his lawyers. Here, dying declaration, no lawyers or accused or magistrate need to be present here. Difference between dying declaration and dying deposition is also important, as because in the examination you have to understand in this. Usually dying declaration recorded by doctor or magistrate. If the time allow you, then call a magistrate to record the dying declaration. If you think that patient may die, maybe died before arrival of magistrate, then doctor can take the dying declaration. Here, no oath is needed, no cross-examination held, no need of presence of accused or his lawyer, and dying declaration carry less weightage than dying deposition. Dying deposition recorded only by magistrate, oath needed, presence of accused or lawyers mandatory, carry more weightage. This dying deposition is known as bedside court, as because like court, here dying cross-examination is also occur and it carry more weightage. Now come to the procedure of taking dying declaration. First, inform the magistrate to record the statement. If the doctors think that the patient will not survive till the arrival of the magistrate, then the doctor can record the dying declaration in presence of two witnesses. This witness will never the relatives or attendants of the patient. This witness should be your ward boy or ayah or sister of the hospital. No treatment should delay or avoid while recording. Major role of doctor to determine the mental soundness. If the magistrate record the dying declaration, in that case, doctor's presence is mandatory, as because to certify the mental soundness of the dying person. Now come the recording. If the patient is able to write, he will give the written statement. If he is unable to write, then record what he state. No leading question, no suggestion, no outsider is allowed to present during recording his statement. He record if any question asked him, record also that question and what he answered also. If the victim, if the person cannot state in that situation, he can put some question to him, and if he made any sign, record that. After recording, you read the statement to the patient and then take the signature of the patient or thumb impression of the patient, then signature of the doctor, signature of your witness, your two witness, and after that you send it in a confidential envelope to the magistrate. Send this declaration in a confidential envelope to the judicial magistrate. This is the procedure of taking dying declaration, and it is one of the important skill that every doctor may have to face in their professional life. And it is the legal right of the patient. Patient whenever come to a doctor, not only for curative, not only for therapeutic purpose, but also legal purpose, he may also come to the doctor. Now come the procedure of recording evidence in the court of law. We already discussed about the summon and evidence. Among evidence, we describe oral evidence and documentary evidence. Oral evidence and documentary evidence, among these two, oral evidence is more important as because here is a chance of cross-examination. That's why oral evidence is more important than documentary evidence. Among the documentary evidence, we state that medical certificate, medical reports, and dying declaration. And we also explain the procedure of taking dying declaration. We also differentiate dying declaration from dying deposition. Now come to the procedure of recording evidence in the court of law. First, receiving the summon, then attendance in the court. Where you attend, you give your attendance in the court. You have to attend in the court in the public prosecutor's office. And here you give your attendance, and he will produce your attendance to the court. The public prosecutor will inform the court about your attendance. Then deposition. Deposition, first oath taking, examination in chief, then cross-examination, re-examination, and question by judge. And then you give the signature, and then with the permission of the court, you leave the court. These are the procedure of recording evidence in the court. Receiving someone, attendance in the court. Here you give your attendance in the public prosecutor office. Then deposition in the court. Under deposition, these 5, that is oath taking, examination chief, cross-examination, re-examination, question by judge. And then you sign that what you deposit your statement, signature of the witness, and then with the permission of the court, you can leave the court. Parts of deposition. Deposition, this is a statement of a person under oath in the court of a law, recorded by magistrate in presence of accused or his lawyers. Dying deposition, this is a statement of a dying person. Dying deposition and deposition. Dying deposition, this is the deposition of a dying person. And deposition means deposition of the witness. A statement of a person under oath in the court of law recorded by magistrate in presence of accused or his lawyers. I have already told you this deposition has 5 parts: oath taking, examination chief, cross-examination, re-examination, and question by judge. Every step has importance, and you should sometimes you have to explain it. Or I will speak the truth, the whole truth, and nothing but the truth. Without oath, no statement is accepted as a testimony. Without oath, no statement will be accepted in the court as a testimony. Perjury, there is a term perjury. Definition of perjury is important for examination. Giving willful false evidence while under oath. Giving willful false evidence while under oath, or failure to tell what he knows or believe to be true. This is perjury. And for perjury, punishment up to 7 years imprisonment or fine. If it is proved you are giving willful false evidence under oath, then you have to face this punishment. In the examination in chief, you have to explain about the facts, for what purpose you attend this court. In your in the direct examination chief, public prosecutor will assist you, but you have to give a statement in your own. Then cross examination, this is done by the cross examination usually done by the opposite lawyer. Examination chief here, you can take assistance of the public prosecutor. Public prosecutor PP will assist you in the cross examination, usually conducted by the defense lawyer. Defense lawyer. And re-examination is usually done by the public prosecutor. In the examination chief, what you state, if anything is away from this by cross examination, then the public prosecutor re-examine you to clear that points. And if judge thinks, he may ask you some question, that is question by judge. Now come the purpose of cross examination, done by lawyer of the opposite side, that is defense lawyer. But if you declared hostile witness, this is another issue. Usually hostile witness, to declare hostile witness, public prosecutor, usually all the witness are in favor of plaintiff. Whenever public prosecutor thinks that you are not giving you are concealing some truth, or you are not giving your evidence is differ from your previous statement, then he can propose to the judge that I am declared him as a hostile. If does accept you as a hostile, then you will be hostile witness. And if you are hostile witness, then the cross examination usually done by the public prosecutor. Usually cross examination is done by the lawyer of the opposite side, that is defense lawyer. No time limit for cross examination. Try to get facts from the witness favorable for his case. Try to nullify the submission recording the examination in chief. Your trustworthiness, your inconsistencies in your statement, etc. To test the accuracy of a statement made by you, to modify or explain what has been said, to develop new or old facts, try to prove the lacking of witness, either efficiency, competency, memory, or intelligence. These are the purpose of cross-examination. Now come to the witness. In the course procedure, we already identify three things. One is summon, another is evidence, another is witness. Witness is the person who narrates evidence in the court of law. Types of witness: common witness, expert witness, and both may be hostile. Usually two types of witness: one is common witness and expert witness. Common witness is evidence about facts observed or perceived by him. Evidence about facts observed or perceived by him. Expert witness, the person trained or skilled in scientific or technical matter and capable of drawing opinion and conclusion from the fact observed by himself or noticed by others. Doctor, as a doctor, he may be common witness as well as expert witness. Suppose you are giving evidence regarding injury certificate in the court of law. Whenever you describe an injury, its size, a length, breadth, depth, site of injury, etc., then you will be common witness. Whenever you describe it is the incision, it is a blunt force incision or abrasion bruise like this. Whenever you give a opinion, draw an opinion, this is caused by the sharp cutting weapon, or this is caused by the blunt weapon. This is grievous in nature or simple in nature. Age is less than 6 hours, etc. Age of the injury. That is, you can, whenever you conclude a opinion, you give a opinion, then you will be expert witness. And common witness, expert witness, both may be hostile. I have already explained you whenever a witness may be hostile. Hostile witness who has supposed to have some interest or motive for concealing part of truth or giving false evidence. Then public prosecutor, if he thinks so, he proposed to the judge that I am declaring the witness as a hostile. If the judge accepts you as a hostile, you will be a hostile witness. And if it is proved that you are giving willful false evidence under oath, you will have to face punishment of up to 7 years imprisonment, also fine. But only if you declare by him as a hostile witness, you may not have to face those punishment for perjury. Another important conduct of a doctor in a witness box is very much important. This is one of the important skills that every doctor needed. As because people usually used to go to the court either to file a case or for to justice for him or to give evidence. Doctors may have to attend the court as a plaintiff, as a defendant, as a witness. First, well dressed. That is, usually you should put the white coat. This is the symbol of doctor. In the movie, whenever a person wear a white coat, people identify him as a doctor. So well dressed, that is wear the white coat. If you attend the court with white coat, then the person around the court, they will give you some respect to enter into the court. Otherwise, he may not be able to identify you. Well prepared. Usually, doctors need not to take any documents. The certificate or report you are giving, that is preserved in the public prosecutor office, and in there, if go to there and then see the record and be prepared. Take all records and relevant documents. Stand up straight like a gentleman. Address the judge as sir or your honor. Be relaxed and calm, not nervous or frightened. This is one of the important issue. Be relaxed and calm, not nervous or frightened. Never attempt to memorize. Never attempt to memorize. If anything asks you, you see the record and give the answer. Speak and audibly. This is also important as because if you speak not audibly, defense lawyer, he will give some, he will make some noise here to speak audibly. Be confident but not overconfident or arrogant. Be confident but not overconfident or arrogant. Use simple language. Avoid superlative term. Avoid difference between your record and testimony. What you say will not be differ from your record. Be pleasant, polite, and courteous to lawyers in appearance, professional manner, and general behavior are important. Never underestimate the medical knowledge of the lawyers. Never become angry, hostile, rude, sarcastic during questioning. Don't argue, just disagree. In our case, while I am giving evidence, public prosecutor, a defense lawyer told him, do you declare him hostile? Public prosecutor told him that no, I am not declaring him a hostile. He asked me a question whether I passed HSC or MBBS, whether I copy in my examination, like this irritable questioning. But I'm simply say it is not true. Like this, don't argue, just disagree. Avoid long discussion. These are the features of an ideal witness in the court. Ideal witness. These are features of an ideal doctor as a witness. So this skill is important, and some doctor, whenever have to face this, he may be frightened, maybe anxious. And if you go to the court, if you prepare yourself, you'll find it informative. So today we discuss about summon, about evidence, regarding evidence definition, type, procedure of recording, dying declaration, medical document evidence, etc., perjury, and witness. Thank you very much. Assalamu alaikum warahmatullahi. If any question, you can ask, you can give your comment, and you can ask, or you contact to the authority. They will provide. Thank you very much. Assalamu alaikum warahmatullah.